A 2015 High Court case, HCA and Myriad genetics focused on whether an isolated nucleic acid coding for a mutant or polymorphic BRCA1 polypeptide was a patentable invention. Patentable invention is found within Section 18(1) of the Patents Act 1990 with regard to manner of manufacture within Section 6 of the Statute of Monopolies. The High Court focused on whether the claim was a product or process created by human intervention, an artificially created state of affairs which produced an economically useful result, and was not a mere discovery or idea. The presence of BRCA1 indicates mutations which place women at a high genetic risk of developing breast cancer and ovarian cancer. The majority held that the substance of the patent was the information embodied in the arrangement of nucleotides. This information was not made by human action, it was discerned. The High Court unanimously held that the BRCA1 patent was not valid, as it did not fall within the definition of a manner of manufacture of Section 6 of the Statute of Monopolies. The High Court also stated that the patentability of a gene or genetic material should be something for the legislature to consider or expand on, and the significance of any international obligations like TRIPS should be for their consideration. Myriad's decision means that patents relating to genetic material may be challenged and further applications will likely be denied. Myriad has been applied in regard to cases not concerning genes already. In Commissioner of Patents and RPL Central, the court's interpretation of manner of manufacture was considered and applied in respect to a computer program. The High Court throughout the case had regard to the chilling implications that gene patents could have on research and development of genetic testing and the potentially negative effects on innovation. Throughout it was raised that someone extracting genes and testing them without any purpose related to BRCA1 would be in breach of the patent if they extracted the nucleotides which code for BRCA1, which is something that would be unknown until after the extraction process. There was no way to prevent someone from accidentally breaching the patent. They also emphasized that the process for extracting BRCA1 is not new or patented or unknown in research and development. Attention throughout the case was drawn to the parallels of Myriad's conducting of BRCA1 testing in the United States, where the cost of testing is significantly high and in some cases prevent women from being able to partake in the tests and thus, in reality, limit their exposure to healthcare. In Association for Molecular Pathology and Myriad Genetics, the Supreme Court held that the BRCA1 patent was invalid. Myriad operates through Genetic Technologies Limited in Australia, which has stated it would not enforce its patent in Australia for public laboratories, even though testing would have been subsidised anyway. The Australian Law Reform Commission has in the past refused to acknowledge that gene patents have an impact on the cost of healthcare. An impact the Cancer Council Australia says reduces public access to genetic technologies in cancer control and increases the cost of genetic technology for both government and community. Gene patents in some situations can result in higher healthcare costs, especially when the biotechnology company is the only avenue for the testing, but they also represent an incentive for companies to invest in the medical research industry and provide protection for the owner of the patent. Whether Myriad's case, which means patents relating to genetic material existing or any that will arise in the future may be invalid, will affect the medical research industry cannot be discerned this early. In summary, HCA and Myriad Genetics concerned whether an isolated nucleic acid coding for a mutant or polymorphic BRCA1 polypeptide was a patentable invention. The High Court held it was not, as the claim rested in the arrangement of nucleotides, which were discerned and not made by human action.